Hello, everyone, and welcome back to another episode of LG Radio. I am your host, Lynn Green. Today, we recap how we got to a YSL mistrial consideration. Make sure you hit that like button, make sure you subscribe. We're going to jump right into it.
Welcome back. It's coming up on 12:15, and we've got breaking news regarding the YSL racketeering case that has taken place for months at the Fulton County Courthouse. Now, once again, the trial needs a new judge. Newly appointed presiding judge Shakura Ingram has now recused herself from the case. The judge cites the arrest of a Fulton County deputy who was once assigned to her courtroom, who was in a relationship with one-time co-defendant YSL Christian Eppinger. Now, even though Eppinger is no longer part of this trial, Judge Ingram ruled she should disqualify herself because the public could question her impartiality. Now, the judge's action follows the removal of presiding judge Earl Glanville from the case. Another Fulton County judge removed Glanville, who was Fulton County's chief superior court judge, after weeks of contention between Judge Glanville and defense attorneys. Right now, there is no word on when a third judge will be appointed or when that trial will resume.
A couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm going to go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yes, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closets. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now. There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about? and why that's necessary. And if nobody wants to, then we'll just do away with it.
I think it was originally to combat boredom.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay? Yes, sir.
Good morning again, Sergeant Master Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature, and I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
I certainly understand that. Just maximizing the time that I have with my clients since I don't have availability with him outside of court every day. So he's here, we're here. So a lot of times I'll give him an opportunity to review evidence and things of that nature. So
All right.
that would be the only reason I want to ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think you'll know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. But I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence, and I might end up using that. So how about y'all give me a heads up on all of that, okay? And if that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see, what's next on my list? With regard to kind of just general scheduling, other than the week of the 29th. And then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay?
All right, so Judge Whitaker comes in, sets her ground rule, catches everybody up on how she would like to run things. But she shows another side that I like, basically, because the trial been going on 2 years.
Your Honor.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor.
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments.
I'm sorry, what?
Pay attention to what they talking about. For my new subscriber, the link to the rest of the video in the description.
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked it.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous, because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what. I
think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have time after time after time continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Well, I don't know what to say, but it don't look good for the state moving forward. We can go ahead on and go to the next video.
Insert error into this trial to make y'all ask for a mistrial so that they can try this case again. I think it is continued, and I am sorry. Y'all have, this gigantic, ginormous universe of evidence. Would not be making these kinds of mistakes, but I believe that to be a mistake.
Your Honor,
So I'm going to deny a motion for a mistrial with prejudice. That one, I don't believe that the facts bear out. Would you like a mistrial without prejudice?
yes.
You would?
All right, so a mistrial and a case dismissal, two different things. Keep that in mind.
Who else would? That means, of course, that the state would be free to try every one of y'all again.
Judge, just a moment.
Sure. That means, of course, that the state would be free to try every one of y'all again.
The court's ruling.
So could you share with us all of the whatever parts you think actually you would like to have admitted and published?
Yes.
Can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me. For anything.
Okay, let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right. Thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation and he can
authenticate these.
I believe that.
Okay, maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
If you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they look at the
Do you
they
remember?
have.
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can.
Resending it would be great, and then
yeah.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier.
Okay.
Okay, so you will do that and be specific about what parts you want in. All right, Mr. Shart, you had asked
in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date? Or
Yes, I would very much appreciate the court giving
Okay.
that instruction.
And that was
because
states 44, I mean, not states, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check. I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will that work? Yes, no?
Yes, that would
Okay.
be great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right, I would also, let's see. So we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The additional crime scene photos
Your Honor,
from Mr. Atkins.
I don't know if we'll get to that or not.
Okay.
When would that be coming in?
not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, they
next.
may not be
depending.
coming in at all.
Well,
but
if
you-
they are to come in, it would be in about 2 weeks from now.
Okay, and it was so like, you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are going to be crime scene photos of and why, like what crime scenes and why? I know, Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about that?
So at the begin, you want to know the actual
Crime scenes.
Okay.
And then why did you have to add those witnesses back in?
Well, the why was when counsel for
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
that was half of it. The other
Okay.
half was that they objected to any of the
Chain of custody, I remember.
right.
Anything
right.
beyond that?
Yes. So I'm pulling up the actual
Okay.
incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I
No.
understand.
Okay,
I'm
thank
going
you.
to get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
Well, one was 2014, one was 2015, one was 2019, as I understand it. Which was that?
That was 2014.
Okay.
And that was based on an objection about the Nibin hits. And then there was the 807 Prior and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle
Where?
on the road. It was, the specific address was.
This is something there was just testimony about last week. Yes, no?
Oh, yes, I'm sorry, I thought you. Yes. That was rhetorical.
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Adkins represented in his email, then why should they come in now?
Your Honor, so as it relates to the scene, we believe that it's relevant information that does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that they have not.
Well, Mr. Adkins represented that they hadn't.
And I have no reason not to
Okay,
believe.
so you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put him in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. But I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Yeah, are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then, yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and you base it on Davis versus State, 307 Georgia 746 from 2020, and also Adkins v. State, 301 Georgia 153 from 2017, and the law that's set forth in those about conduct of an investigation, an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands. So I'm going to overrule your objection. You may have a continuing objection to that. All right. See y'all back at 1:20.
Just for you to know, we speak with independent crime scene people, so the state just giving us this, these photographs, and then we have to review the evidence, and then go talk to the witnesses. It's a hassle for us.
So if she lets me know that these were originally provided, that's one thing, but if they were not, then they're not going to be coming in. All right. See y'all in 30 minutes.
1 hour later. Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said Free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it, and then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And, Your Honor, before we had the opportunity for you to preside over us, this happened already again. And before, and I made a motion for a mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews for Mr. Marquavius Huey. We join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you know when to come back in, okay?
So we join in that motion, Your Honor.
Your Honor, and I just want to briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped them, and this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, it's been established that that his nickname is Quay.
Okay, isn't there going to be, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? We did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
All right, so the they keep referring to is slang like shouting. His testimony.
And we should have instructed him to read from the screen, but
or you should have presented him with a document that had that part redacted. It's just sloppy. The
issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, "I'm going to have an issue with that. Can you redact it?" That is when the state became aware.
Then it should have occurred to you, you know what? I'm handing him a hard copy of this document that is unredacted.
But not if there's multiple Quays, Your Honor. If I don't know which Quay that they
Hang
were-
on. Can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God have mercy, y'all. Huh?
The state is in charge of the witness, and they're supposed to be guiding the witness to the room.
Yeah, I mean, there seems to be.
And so that is the point in which we learned of it is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
when
and
I
you
came
didn't
back-
read that. I mean, so the
But I
jury
said-
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis because there is going to be this stipulation that Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay spent time in jail or in custody or in prison or anything. I mean, they say it about, Hollywood stars who are in a breakup. It's not so obviously, oh, this must mean this person was in prison. But also, we were already saying Quay isn't either of these people. So let's just, and whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of Quays.
You talked to his attorney earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this was
wasn't
one
an
of the
issue
things you were going to, but it's an issue now. And you said before lunch that you were going to ask Mr. Rubin.
Yes, we did ask.
Do you know at this point whether the free Quay referenced, this wasn't even his post, was it?
It wasn't, and there wasn't an issue until Ms. Westmoreland. So when I talked to Mr. Rubin at lunchtime, this wasn't something I was going to address with him because it wasn't I did not realize it was an issue. Mr. Rubin found out for me that Slat Quay is not either of these two Quays.
Okay, but this isn't Slat Quay, this is just Quay.
Right.
I know. So why doesn't everybody, well, they don't know how it's spelled, they only heard it. Why doesn't everybody just enter into some sort of a stipulation that the free Quay or the reference to Quay just now isn't either of these people?
I don't know if it is, so it was.
Whether it, okay, so.
Your Honor, the state can enter stipulation that we weren't referencing any. We, as the state of Georgia.
Okay, that is not a reference to, if you would prefer that.
I don't know what the poster is referencing.
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness. So that everybody won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can come up with this.
Okay, do it now. Y'all work on that. I'm going to take 5 minutes.
3 hours later. The next day.
I'm going to publish 37 NN. Who?
All right, so today they didn't have no court. We're on the verge of possible mid-trial. This is the last thing that happened in the YSL trial before the break. Make sure you hit that like button. Make sure you subscribe. Let me know what you think in the comment.
Is in 37 NN.
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
Said, ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay. And is there another hashtag?
Free Quay.
Is there another hashtag on the screen?
Oh no.
Your Honor.
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm going to excuse
I
you.
wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute? And jury, I'll excuse you all for just a minute. Mr. Lee, can you step outside for a minute for me, please? Thank you.